Namaskar and welcome to Delhi Law Firm. Today we are going to discuss a very important legal topic in depth, Sapinda relationship, and how it directly impacts Hindu, Muslim and Christian marriage laws in India. Marriage is not merely a union between two individuals, it is the merging of two families and two lineages. Therefore, it becomes essential to understand which relationships are permitted for marriage and which are not. So let us dive into this significant subject.
The topic of Sapinda relationship is not superficial, it is deep, detailed and multidimensional. Generally, people associate it only with the Hindu Marriage Act, whereas in reality, every religion, Hindu, Muslim or Christian, restricts marriages within close blood relations in one form or the other. The terminology differs, but the objective remains the same: protection of lineage, society and future generations. Hindu law calls it Sapinda, Muslim law identifies it as prohibited degrees of consanguinity and fosterage, and Christian law calls it consanguinity and affinity. Let us understand all three systems in detail.
First, let us talk about the Hindu Marriage Act 1955, where the most detailed and scientific definition of Sapinda relationship is provided. Section 3F and Section 5V form the backbone of this concept. According to Section 5V, a marriage is valid only when the parties are not sapindas of each other, meaning they must not be related in a prohibited degree of blood relationship. It is also necessary that such marriage may be permissible if there is a proven customary practice within the community. Family consent or personal preference is not custom. A valid custom must be ancient, consistently practiced, and socially recognized.
Now let us simplify the language of Section 3F. Under Hindu law, on the maternal side, marriage is prohibited within 3 generations: you, your mother, and your maternal grandparents. On the paternal side, marriage is prohibited within 5 generations: you, your father, your grandfather, great-grandfather, and great-great-grandfather. If two individuals share a common ancestor within these limits, they are considered sapindas. This rule is not only religious, but scientific as well. Close kin marriages increase the risk of genetic disorders, which is why society and law take this restriction seriously.
Now let us understand the legal effect of a marriage conducted within the Sapinda relationship. According to Section 11 of the Hindu Marriage Act, such a marriage is void ab initio, null and void from the very beginning. It is treated as if the marriage never took place. However, Section 16 clearly states that children born from such a union are considered fully legitimate. This is an important social and humanitarian safeguard for protecting children's rights.
Now let us examine some important judicial decisions. First, the famous 2023 Delhi High Court judgment Neetu Grover versus Gagan Grover. In this case, the husband and wife were children of real brothers, meaning they shared a common ancestor within the prohibited 5 generations. The wife argued that such marriage is recognized as a custom in her community. But the court held that a custom must be proven through strong, historical, continuous and socially accepted evidence. Family permission or isolated instances do not constitute custom. The court declared the marriage void under Section 11.
Exactly, and this judgment makes it clear that courts apply Sapinda rules very strictly. Now let's examine the 2024 Allahabad High Court case Shyam Kumar Mishra. Here a detailed family lineage chart was presented which clearly showed the parties were Sapindas. The court declared the marriage invalid. This proves that courts rely on factual genealogical evidence, not mere allegations.
Now let us move to Muslim marriage law, where the idea equivalent to Sapinda exists under different terms. Muslim law prohibits marriage in 3 major categories: consanguinity, affinity and fosterage. Under consanguinity, a man cannot marry his mother, sister, daughter, niece, maternal or paternal aunts. Under affinity, marriage with wife's mother, stepdaughter or daughter-in-law is prohibited. The unique feature in Muslim law is fosterage. If 2 children have been breastfed by the same woman, they become milk siblings and marriage between them is absolutely prohibited. This is both socially and biologically significant.
If a marriage is conducted within prohibited degrees under Muslim law, it is considered batil, completely void. However, even here, Indian civil law does not render the children illegitimate. This reflects the humanitarian approach of Indian legal principles that protect children regardless of marital complications.
Now let us understand Christian marriage law. The Indian Christian Marriage Act 1872 and canon law regulate Christian marriages under strict religious discipline. Here, marriage is prohibited within consanguinity and affinity. This includes direct line relations, parents, children, siblings, uncle, niece, aunt, nephew. According to canon law, marriage is prohibited up to 4 degrees. These rules aim to preserve social stability and protect family structure.
Thus, we can see that although the terminology differs across Hindu, Muslim, and Christian laws, the principles and objectives remain the same: protecting society, family, and future generations by prohibiting close-kin marriages. These rules are not merely traditional, but inspired by scientific research and genetic safety.
And modern science also confirms that close-kin marriages increase the chances of genetic disorders, birth defects, and other health risks. Therefore, religious, social, legal, and scientific viewpoints converge on the same conclusion. This makes Sapinda rules not just a legal issue, but a matter of public health and societal well-being. Courts also recognize the sensitivity of this issue. In 2024, the Delhi High Court upheld the constitutional validity of Section 5V, observing that this restriction does not violate personal liberty but serves public policy and societal welfare.
When the issue of Sapinda or prohibited relationship arises in court, detailed family lineage charts are demanded. Both parties must produce generational charts with evidence. Mere emotional claims or family opinions cannot prove lineage. Proper documentation is required.
And if a party claims custom, the court applies strict standards. To prove custom, it must be shown that it is ancient, continuously practiced, widely recognized by the community, and not against morality, law, or public policy. Thus, proving custom is extremely difficult.
In conclusion, Sapinda relationship is a central pillar of Indian family law. It governs marriage validity, lineage protection, biological safety, and social order. Similar provisions exist in Hindu, Muslim, and Christian laws, showing that this concept is universally significant.
And finally, if you need legal help regarding Sapinda relationship, marriage validity, prohibited degrees, annulment, void marriage, conversion marriage, or any other matrimonial or family law matter, Delhi Law Firm is here to help you out. We handle all matrimonial and family cases across India, including court marriage matters, domestic violence, maintenance, 498A, custody, and all related disputes.
For more information, legal advice, or case filing, visit our website www.delhilawfirm.news.
Thank you, Delhi Law Firm, your trusted legal partner across India.